Good evening. Welcome to the monthly meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I'm Judy Freshman, Chairman of the Board. The Board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Intamalis, Paul Melnick, and Peter Owen. Also present is the professional staff, including Stephen Rissy, Coordinator for the BZA, Cliff Hogan, Assistant to the Zoning Administrator, and Simon Keynes, Administrative Technician. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen the report for your case, that you get a copy and review it before your case is called. The Board's powers are prescribed in the Code of Virginia and set out in further detail in the county zoning ordinance adopted by the County Board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the County Board. This Board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots, where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the Board find that the proposal meets conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plan and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood, because the structure's overall footprint, size, and placement are similar to the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that it meets the following criteria. The strict application of the terms of the ordinance would unreasonably restrict the utilization of the property, or granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, and the property for which the variance is being requested was acquired in good faith, and any hardship was not created by the applicant, that the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, that the condition or situation of the property concerned is not of so general or recurring a nature as to make reasonably practicable the adoption of an amendment to the ordinance, that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning and/or subdivision ordinance. When deciding appeals of the zoning administrator, the Board must use its judgment to determine if the zoning administrator was correct. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, Board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the Board may permit the applicant a brief opportunity to clarify any points. The Board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient: 20 minutes for appellants in appeals, 5 minutes for applicants for use permits and variances, For use permits and variances, we've deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Case number V-10888-14-UP-5 is a use permit request by Elaine Kaputska, owner, to permit a setback of 10 feet to the eave of a new third-floor addition from the 21st Road North right-of-way instead of 25 feet as required, and to permit a building in excess of 2.5 stories within 25 feet of a street right-of-way regarding a new third-story addition above the existing second-story walls in an R5 zoning district on the premise known as 4133 21st Road North. Staff recommends that the board defer the use permit to the February 2018 BZA hearing. Please note that there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you. Questions for staff? Mr. Owen?
Yes, I noted that the financial disclosure form on this item didn't seem to be fully filled out, so I trust and hope that that might be remedied by the time we next see the item.
Seems like we could take care of that between now and February.
Great.
Do we hear a motion?
Madam Chair.
Mr. Smith?
Case V-10888-14-UP5. I would move that we defer the case to the February meeting of the BZA.
Second.
It's been moved by Mr. Smith, seconded by Ms. Malice, to defer the item to February 2018 BZA meeting. All those in favor?
Aye.
Thank you. Next case, please.
Case number V-11268-17-VA-1 is a variance request by Mount Zion Baptist Church, the owner, to permit a development of a lot that does not meet the width and area requirements regarding a new 3-story dwelling in the R27 zoning district on the premise known as 1913 South Langley Street. Staff recommends that the board adopt the motion to defer the subject variance permit to the February 2018 BZA hearing.
Madam Chair?
Questions for staff?
Madam Chair?
Mr. Owen?
In our materials, the applicant submits an email saying that staff has raised a number of compelling issues that will need to be addressed prior to the next hearing. Do you have a sense of what those issues may be that staff has raised?
Yes. Staff presented the amend advertisement that would need to be run if the building were to not be used for single-family use, as was brought up at the prior meeting. So that's the issue there.
Got it. All right. I also submitted an email to staff where I had some questions about the financial disclosure, which hopefully the deferral will give plenty of time to sort through.
Again, correct.
We do have 2 speakers on the variance.
Oh, we do? All right.
Harry Thompson.
Good evening. I'm just here to assure you that Mount Zion Baptist Church will address the issues that were raised by staff and the issue for the signature of the owner of the property. The church bylaws designate the church, the trustee chair, to be the authorized signatory on such document, but we'll work with staff to develop that.
Thank you. Questions? Jacqueline Coachman?
Good evening. I'm Jacqueline Coachman. I reside at 1921 South Langley Street, and I'm here to speak in support of the deferral. You may recall that at the May meeting, one of the reasons these cases were deferred was because they had not been presented to the community. They did present at the June Knox Civic Association meeting, which was very well attended, and there were a number of concerns, not only about the project, but just life in general, living with Mount Zion. If I were to summarize those comments, I would say they are rooted in the long-standing and well-established reputation of Mount Zion as the neighbor from hell. They agreed to have a meeting later in June, a town meeting. That meeting was canceled. We never heard any more about this project until a meeting about 3 weeks ago. It was a very nice meeting, great refreshments, but what was missing were these plans. They presented no plans whatsoever for this project. They talked about the project. And I mentioned I was incredulous that you could have this meeting and not present the plans. And I was told they were addressing the concerns that were raised at the Civic Association meeting, although there were plenty concerns raised about this project. Now, what is most significant is at no time did they mention this project is now 3 stories. When this was presented at the Knox Civic Association meeting, it was 2.5 stories. Nothing was said about that at the meeting 3 weeks ago. So I asked, are you going to defer this case? I couldn't believe they would bring this case back to you without presenting anything to the community. So I don't know what we have going on here is amazing ignorance of the process or amazing arrogance and disregard for the process. But I hope that by the time they come before you in February, all of these concerns have been addressed. Thank you.
Thank you. Mrs. Malice.
Mrs. Coachman, may I ask you a question?
Sure, I'm sorry, I didn't know who was speaking. Sure.
Are you aware of any plans for community meetings between now and February?
Well, no, they didn't mention any, but this meeting was maybe October 24th, and at that time there was no discussion about future meetings.
Okay, so you would expect that there would be another meeting or a series of meetings when there's actually plans to look at?
Yeah, especially to make the community aware that this project is now 3 stories. It was originally 3 stories. They agreed to make it 2.5 stories, and now it's 3 stories again. And nothing was said to us about that.
Okay.
Thank you.
Thank you. Comments? Motion?
Madam Chair,
Yes, Rowan.
I guess we have a representative from the applicant here who spoke earlier. I'm sorry, I can't remember your name, sir.
Thompson?
Thompson. May I ask you a question? Mr. Thompson, do you know of any plans for additional outreach to community members between now and February?
Yes.
Can you describe them?
There will be at least 2 additional outreach opportunities to the community before the February meeting.
And what sort of outreach will that be?
We plan to have another meeting with the architect and the community to host them, to give them more details on exactly what the building will be used for and what it will look like.
And who do you intend to, or who are you going to reach out to attend those meetings? Is it just the Civic Association or individual neighbors or a combination or?
Combination of all. We reached out. We actually sent invitations to the neighbors, everyone on Langley Street, and we reached out to the Civic Association also.
Thank you.
Thank you. Motion?
Madam Chair,
Ms. Malice.
I move that the Board of Zoning Appeals defer the variance V11268-17-VA-1 to the February 2018 BZA hearing.
Second.
Moved by Ms. Malice, seconded by Mr. Owen to defer the variance to the February 2018 BZA meeting. All those in favor?
Aye.
Aye.
Thank you. Next case.
Case number V-11268-17-UP1 is a use permit request by Mount Zion Baptist Church. The owners to permit a setback of 18.9 feet from the wall to the front property line instead of 25 feet as required, 12.4 feet from the porch to the front property line instead of 21 feet as required, and to permit the placement of a 3-story building within 25 feet of a street right-of-way regarding the new 3-story building in the R27 zoning district, premise known as 1913 South Langley Street. Staff recommends that the board adopt the applicant's request to defer the use permit to the February 2018 BZA hearing.
Madam Chair,
Ms. Miles.
may I ask a question of staff? This description of 3 stories, has it always said 3 stories, or has that description changed since we heard it first?
My understanding is that's the original description that you've heard.
Thank you.
We all have the same 2 speakers. Did you have something you wish to add? You're welcome to do so. Mr. Thompson and Ms. Coachman.
The only thing I'll say, and I was looking for it in the staff packet, I think there is correspondence from Mount Zion to the community that talks about 2.5 stories.
Okay. Mr. Thompson.
An opportunity to shed some clarity on this 2.5, 3-story issue. The building is, because of the setbacks, are required to reduce the size of the 3rd story. Some people see that as a half a story because it is not the same square footage as the floors below it, and it was called 2.5 stories. Originally, it was described as a 3-story building, but the top is less square footage because of the required setbacks on the front and the back. And that was the language, I think, that was a bit confusing for the community between a 2.5 and a 3-story building. It will have 3 levels. The top level, it will be substantially smaller in square footage.
So it appears when you have your community multiple meetings, there's a crying need for clarity there,
Absolutely.
among other issues, but that's fine. Great. We look forward to that.
Thank you.
Other comments or motion?
Madam Chair,
Ms. Malice.
I move that the Board of Zoning Appeals defer use permit V11268-17-UP-1 to the February 2018 BZA hearing.
Second.
Moved by Ms. Malice, seconded by Mr. Smith to defer the use permit to February 2018 BZA meeting. All those in favor?
Aye.
Thank you. Next case, please.
Case number V-11301-17-VA-1 is a variance request by 2205 Shirlington LLC, the owner, to allow additions to a non-conforming building in a C2 zoning district and to permit a setback of 29.5 feet to the frame wall for utilities instead of 40 feet as required from the Shirlington Road center line, and to permit a setback of 34 feet to the wall of the addition instead of 40 feet as required from the Shirlington Road center line, and to permit a setback of 11.5 feet to the frame wall for utilities instead of 40 feet as required from the 22nd Street South center line, and to permit a setback of 27.2 feet to the wall of the addition instead of 40 feet as required from the 22nd Street South center line regarding the renovation, recladding, and additions to a non-conforming structure on a corner lot in the C2 zoning district on the premise known as 2205 Shirlington Road. Staff recommends that the board adopt the attached resolution granting the subject variance request with conditions. And please note there is supplemental material for this case that came in after the application packet was assembled and printed.
Questions for staff?
Madam Chair,
Mr. Owen.
describe the supplemental materials that we were given.
You were given an updated disclosure statement that addressed your question as to who was part of the 2205 Shirlington LLC.
Additional question is, in the staff report, staff analyzes the legal criteria for a variance. And there's two alternate criteria, one of which is, would the strict application of the terms of the ordinance unreasonably restrict the utilization of the property? And I don't have any questions about staff's analysis under that prong. And either prong is sufficient to grant a variance. But I did have a question about staff's analysis under the second, older criteria for variance. Would the granting of the variance alleviate a hardship due to a physical condition relating to the property or improvements thereon which existed upon the effective date of the ordinance. And this is a existing non-conforming property.
Correct.
So the analysis appears to say that the only developable portion of this parcel is a 5-foot sliver of land, but that's developable. Isn't it true that there's already a useful building on the site?
There is a building on the site. I know the applicants are applying for the variance because they're saying they need to do these additions to fit their use in that building.
Their preferred use.
Well, I don't believe the building is currently in use.
So does staff have a position as to whether or not the current building has any viable economic use?
I would say that it doesn't have current viable economic use for the intended purpose the applicant has.
Okay. I guess to me that seems like a novel interpretation of the criteria and not one that I have seen before recently. So I was surprised by that analysis, but thank you for explaining it.
I also had one question of staff. On page 3 towards the bottom, in response to question number 3, you state that the existing condition is unique and not generally found elsewhere. Is that a result of an analysis that you did, or?
Well, looking at the property, we don't have many properties that are used commercially this thin next to a roadway, which would take up the majority of the property. I just haven't seen another example of that.
Okay, because we have difficult C2 sites, but you're saying this is particularly difficult
Yes.
because of the being a corner lot. Okay.
Madam Chair,
Mr.
do you have any sense of how many parcels under 37,000 square feet, 3,700 square feet, there are that are Zone C2 in Arlington?
Not offhand.
Okay. Thank you.
Applicant? Mr. Lawson? Is this?
We're having a little bit of trouble hearing. I don't know if the mics aren't loud enough or something. Ladies and gentlemen, for the record, my name is William B. Lawson, Jr. I represent the applicant. I want to start off by sharing a case with you that's hot off the presses. This was decided November 9, and the reason it's important, they talk about res judicata, but it's important because it revolves around the new standard for variances. And the Supreme Court talks about how approaching confiscation was deleted from the statute. I'm going to hand this out for your all's use, and also an article that was discussing the case. So I'll give that to you all momentarily. The staff has done a good job with the test. I want to talk in a little bit more detail about the hardship. And in doing that, I'm going to read from the statute. And what the statute says, it says, where by reason of exceptional narrowness, shallowness, size, or shape of a specific piece of property at the time of the effective date of the ordinance. And so that's exactly what we have here. We have a small, narrow lot, and that certainly meets, that criteria. The statute then goes on and says, or of the condition, situation, or development of property immediately adjacent thereto. And so in this case, we have property immediately adjacent here too, which is the streets. And so again, we meet that. Under the 1950 ordinance, commercial property is supposed to have 7,500 square feet of area and 75 feet of width. As best I can tell, and sometimes the old ordinances are really a little hard to follow, When it was subdivided, I don't believe, and don't hold me to this, but it doesn't look like there was a minimum area or minimum lot width. Here we have a corner lot that is abutting substandard streets. Setbacks in the zoning ordinance from the center line of the streets were based upon the assumption that the street was 50 feet in width. If this was an interior lot and it was fronting on a 50-foot wide street, this addition could be done by right, and 90% of the lot could be covered. And so that's the hardship. The hardship is that you can't use it as somebody else could, and it's due to the size, shape of your property and the property that it abuts, and that's what creates the hardship, and that's what makes it difficult to use. This property is non-conforming, and I would respectfully submit that is part of the justification for the variance. The applicant is here, and he wants to discuss the building. The building was a funeral home, and it's not at all appropriate for the use he intends. We did a lot of outreach with the community. We have support, and Mr. Fubini, if you would explain to them the reason for this renovation is necessary.
First, I'd like to thank you for hearing me in regards to this. I grew up in Arlington. I live in Arlington. My wife and I are raising our 3 girls here in Arlington. I am a part of this community. But what I'm most proud of is I built a business in this community. I am not someone who's coming out as an outsider builder trying to fix this, sell it, on to the next. My goal here is to establish my business in this commercial space. I live on Lincoln Street, about 3/4 of a mile or a mile or so away from this, and we would be moving our office, which is currently in Falls Church, to Arlington. So this is my first commercial space, and the goal is to take it, the current property, and turn it into something that's much better than it currently stands. We worked with the Knox Civic Association, spoke with the neighbors, spoke with the townhouse community surrounding us, and got their approval. And the goal is to not just do a minor renovation, it's to completely renovate the space. But that said, it's not to build something that's massive. We are only requesting approximately an 1,800 square foot space, as well as a large garage space. And as you can imagine, running a construction company, there's no heavy equipment or anything like that, but we do need storage for tools and things along those lines. The existing structure is not compatible really with the needs of any office space today. And it's tight, it's cramped, and we just need to rebuild the existing space. Because of the age of the building, many things need to be upgraded, and as a result, by the time we have torn and completely disassembled the building, it makes sense for us to be able to add a little bit of square footage for the office space. We want to comfortably be able to host clients and meetings and really reflect upon the people of the surrounding areas, as well as with our clients and our staff, that, hey, this is a nice, functional space. Beyond that, honestly, I have a lot of experience with real estate. Skylar and Mr. Barnes have done numerous things for me here. Residential. I bought this and have invested over $800,000 on this property and the property next door to it, which is only a gravel parking lot. The county will require that to stay solely as parking. It will be part of the deed that this will be parking for our space. And if I am not granted this variance, it could literally be catastrophic to my business. And so while that error is my own, I am hoping you will work in support for me.
Thank you. Questions for Mr. Fubini or for Mr. Lawson? Thank you.
Madam Chair.
Mr. Wong.
I have a question for staff. Do I correctly understand that the only relief from the zoning ordinance being requested here is relief for placement, setback requirements, essentially?
Well, no, they actually need relief to do additions to the non-conforming building.
Right, but okay, so to do anything at all?
Yes.
And then specifically, but there's not a coverage limitation that
No, not for commercial.
or a height limitation, it's just spreading out this way. So is there a use permit option for the BZA under C2?
No.
Is this something that they could do with a site plan or use permit before the county board?
I don't think so.
Mr. Lawson, can you address this question? Do you have an option to apply to the county board for a use permit or site plan under C2?
I would have to look it up, but I don't believe so. I think the only C2 option is the,
Site plan, it's 40,000 feet minimum, right?
I think so, and I think you would go for the, what is it, UCMUD or whatever they call it now. Yeah, and I think that's your only option in C2, but I'm not 100% sure.
And, but could you do this parcel and this project under that?
I don't believe so.
Okay.
But I'd have to look it up, make sure.
Okay.
Other questions or comments?
Madam Chair, what I'm getting at is that in other situations involving residential property that are not among those that have a use permit option, when someone is requesting setback relief, especially when they are on a corner lot, I think I've seen us apply a standard for variances that's based on the reasonableness criterion that seem equally applicable in this situation. So I'm prepared to make a motion to approve the variance, but but I'm not going to move the staff's motion exactly, if that's acceptable to you, Madam Chair.
Yep. Mr. Melnick.
If I could take a clarification, so you would just go on the first prong of unreasonably restrict and not hardship?
Correct.
Okay, thank you.
So, Madam Chair, I move the staff's proposed resolution, except that I would not include the final whereas clause.
I'll second that motion, Madam Chair.
Okay. No discussion? All those in favor? It's been moved and seconded. Moved by Mr. Owen, seconded by Mr. Smith, to approve the variance for the staff report with the exception of the second whereas?
The last whereas.
The last whereas. Hardship, relating to hardship. Okay. All those in favor?
Aye.
Aye.
Thank you. Next case, please.
Case number V-11307-17-UP1 as a use permit request to permit a setback of 7 feet from the left property line to the wall of a two-story addition instead of 8 feet as required, and to reduce the aggregate side yard to 17 feet from 18 feet as required regarding the addition of a two-story addition to a single-family dwelling. Staff recommends that the proposed resolution granting the use permit request with conditions. Also, please note there is supplemental material for this case that came in after the application packet was assembled and printed.
Questions for staff?
Madam Chair.
Mr. Owen.
Mr. Rissy, can you describe the supplemental material that was given to us?
The supplemental material in your packet includes updated floor plans that shows the removal of the front porch and the changes to the former side porch, which is now the side shoe entry.
Thank you.
Thank you. Any other questions? Applicant, please.
I am Larissa Powell. So we were here in October and we were deferred so that we had the opportunity to speak to our neighbor, and I did that with the help of our architect, Sarah Riddle-Moser, and it was clear from that conversation that we were not going to be able to reach a mutual resolution, and so it may be disappointing to us, but we have decided it's more important to avoid further delays and continue on with our project. So we, like the staff said, we're going to remove the front porch entirely and then just cut back the roof line of the side entrance, so a use permit's no longer required.
Questions for the applicant?
Just want to commend the applicant for doing that outreach.
Okay. Other comments, questions?
Yes, it's for the applicant. As far as neighbor approval,
Yeah.
your other neighbor approval.
Oh yeah, I'm sorry. So that was, I'm sorry, we covered it in October, but, so Westover Baptist Church is on the left side. They sent in a letter, they support it. The neighbor behind us, who the back of their property, they support it. And then actually maybe one other house other than what's in purple up there. So it's 1, 2, 3, 4, like 5 people that are directly across the street support it. So it was really just the property to the right, which is a landlord. We'd only met her once. We've always known the tenants and got along with them. So, yeah.
Thank you.
Thank you. Mr. Melnick,
I'd like to make a motion.
please.
Okay. So in case D11301717UP1, I move that the Arlington County Board of Zoning Appeals grants the use permit request as stated in the resolution with the conditions as stated.
I'll second.
Moved by Mr. Melnick, seconded by Ms. Malice for approval. All those in favor? Aye. Thank you. Next case, please.
Case number V-11296-17-UP1. Sorry, V-11312-17-UP1 is a use permit request by Hugh Robinson, the owner, to permit a side setback of 5.9 feet to the wall of an addition. To permit a side setback of 5.9 feet to the wall of an addition from the adjacent property line instead of 8 feet as required regarding a one-story addition to a single-family dwelling in the R6 zoning district on the premise known as 701 North Frederick Street. Staff recommends the board adopt the attached proposed resolution granting the subject use permit with conditions.
Questions for staff? Applicant?
Good evening.
Hi.
As you recall, the case was deferred till today, so we could meet with our neighbor to see if we could obtain agreement as to how to address their concern. We have met. The neighbor has withdrawn their objection to our request, and I'm here to answer any additional questions.
Would you care to tell us what your settlement is?
Sorry?
Would you care to tell us what you agreed to?
The question was, how would we shield our addition from their view?
Yes.
And they had asked that we put a row of trees on our side of the property line, which would have been impacted us because of the narrowness. We agreed that they would place the trees on their side of the property line, and we would make a payment that would cover the cost of the trees.
Excellent. Thank you. Thank you. We have Steve Kirsch, speaker.
Thank you. I'm Steve Kirsch, 705 North Frederick Street. On behalf of my wife, Deborah, and I just want to thank the board for allowing us the extra month to try to reach an agreement. We did reach an agreement, as Mr. Robinson said, and we have no objections at all to his proposal going forward. And if it is approved, we wish them the best of luck in their addition and the use of it in the years ahead.
Excellent. Any other comments or questions? Mr. Owen?
Once again, I just want to commend the neighbors on working through the discussions you had. I know it's not always easy to have those discussions, but I'm really glad that you did. Thank you.
Thank you. Motion?
Madam Chair,
Mr. Smith?
in the matter of V-11312-17-UP1, I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit subject to the conditions listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Ms. Malice for approval with conditions. All those in favor?
Aye.
Thank you. Thank you all. Next case.
Case number V-11321-17-VA-1 is a variance request by Michael Shipley, the owner, to allow an addition to a non-conforming building in an RA6-15 zoning district and to continue a non-conforming setback of 3 feet to a deck instead of 5 feet as required regarding a new rear deck in the RA6-15 zoning district premise known as 1733 12th Street North. Staff recommends the board adopt the attached proposed resolution granting the subject variance request with conditions.
Questions for staff? Applicant?
I'm just here to answer any questions, and thank you all for your time. Appreciate it.
Questions for the applicant? Thank you.
Madam Chair?
Mr. Owen?
So similar to an earlier item that we heard tonight, I don't agree with the staff's analysis under the hardship prong. So I'm prepared to make a motion for the approval, but striking the final whereas clause on this one as well.
Are you so moving?
I so moved the staff resolution subtracting the final whereas clause.
For V11321-17-VA1.
Yes, that's the one, 11321-17-VA-1.
Got it. And is there a second?
I'll second that, Madam Chair.
Mr. Owen has moved, and Mr. Smith has seconded. A motion for approval of the staff motion with accepting the last whereas with regard to hardship. All those in favor?
Aye.
Thank you. Next case, please.
Case number V-11323-17-UP1 is a use permit request by Richard C. Warden and Carrie A. Thompson, the owners, to permit a front setback of 8.2 feet to the wall, 6.7 feet to the eave of a proposed accessory building instead of 25 feet to the wall, 21 feet to the eave from the North Old Glebe Road right-of-way as required, and to permit a side setback of 0.5 feet to the wall, 0.1 foot to the eave of a proposed accessory structure, carport, instead of 25 feet to the wall, 21 feet to the eave as required from the North Randolph Street right-of-way, and to permit an aggregate side setback of 9.1 feet instead of 24 feet as required regarding a new proposed carport and pool cabana additions to a single-family dwelling on a corner lot in the R10 zoning district on the premise known as 4000 North Randolph Street. Staff recommends that the board attach the proposed resolution denying the subject use permit request. And please note that there is supplemental material for this case that came in after the application packet was assembled and printed.
Consisting of?
For this one, we have a letter from DES stating that they have no current plans to extend the sidewalk from North Glebe Street around the Randolph Street right-of-way. And the other is a plat from 1957 that we found that showed the dedication of a strip of 10 feet of land that used to be part of the subject parcel to be used for road purposes.
Thank you. Questions for staff?
Madam Chair,
Mr. Owen.
I'm confused about where the property line on Randolph Street is as compared to the curb line. Do you have any, can you refer me to any diagrams or pictures that will help me understand the distance between the curb line and the property line?
Unfortunately, we weren't able to put together a diagram to that. The best I could do was that 1957 plat that shows the additional 10 feet. I actually went out and measured the applicant's architect went out and measured the width of the road, found it to be about 28 feet wide. Given the road right-of-way was previously 30 feet, it leads me to believe that there's probably 10 to 11 feet between the edge of the property line and the edge of the curb. But as I've mentioned, I haven't been able to find any plats that show that, so we were unable to put together a diagram for
The
it.
edge of the property line and the edge of the curb in which direction? Is the property line in the roadway, or is the property line behind the landscaping behind the curb?
The property line is behind the landscaping, behind the curb.
Okay, so what we're talking about is a request to be, what is it, 1 foot, how far behind the property line? Half a foot and 0.1 foot behind the property line, which is some number of feet behind the curb.
Correct.
And so Arlington County would have the right to move the curb back all the way up to basically the very edge of where they're proposing to build this.
Yes.
But in fact, right now, there's some number of feet distance.
Correct.
And, okay. Got it. And so, I'm sorry, forgive me if you've just now answered this question, but I don't have it in my head yet. About how many feet are there, do you think, between the curb and the property line?
I think there's between 10 and 11 feet between the curb and the property line.
Got it.
Though I can't
Okay, thank you.
substantiate that.
Appreciate that.
Other questions for staff? We hear from the applicant, please.
brought some photographs that might help elucidate the topic that you were discussing.
Okay, you can bring them up, and then would you stop the time, please?
Thank you.
Thank you very much.
Yeah, one for the file. Thank you. Madam Chair,
And are you yes?
I just want to add that the slides that he has just handed us are also incorporated into the PowerPoint for this evening, so everyone will be able to see them as well.
Excellent. I love it. Is this, and you're Mr. Wooden?
I am.
So you're the applicant? Okay, I have a speaker slip for you. Just want to make sure I understand. Okay, please proceed.
My wife is away on work tonight. She just left. We're seeking a variance from the setback. There is an existing carport there, a car pad, an asphalt pad. The property line is quite a bit behind that curb cut you see, or that's in front of you. I can see it. And right now I'm looking at the sidewalk that was put in recently. I gave them my permission to put the sidewalk in because there was a problem with women, especially walking their babies in the cradles, and Old Glebe was very tough spot. So we put that little retaining wall up in the sidewalk there so they could get off the street, which would be on the side, the corner of where North Glebe and North Randolph meet.
Can I just interrupt for a second? Because we seem to have a discrepancy between the address listed and the property, which is not Vermont.
Vermont.
Correct. No,
We
it's
can ignore that,
4000
but
North Randolph.
it's not correct.
Incorrect up there. I also have a plat survey that was done much more recently than 1955 or 57, whatever it was.
Okay.
This was done, I did this year. We just
Oh,
did
yeah.
this for the project.
That's included as well. This was just showing when the 10 feet was dedicated.
Although we don't show the line connecting the right-of-way, I guess, but you can tell from the sidewalk, if you were to visually draw a line, I think there's, the pole is even, I think, inside the curb. So that curb extends quite a bit out. The driveway just goes out. And I'm simply trying to build a carport, a roof over an existing car pad that happens to be completely out of compliance. Whole thing is inside the setback, so that my car doesn't keep getting wiped out by the winter storms and the summer heat and all the leaves and seeds and berries that ruin it. And we don't have a garage or any kind of a carport. That's what we have, is a asphalt carport. The project would also help with the runoff. I'm an environmental specialist all my life, and I'm going to run the downfalls up at the top of that slope in the ivy and let that run down through there. So we'll get actually less runoff. I'm right on right next to the river there, so that street's going right down into the sewage lines that feed right in. Here's a tape measure that would show where the end of the proposed carport would go. And you can tell, I know you can't turn around and see that, but it's quite a distance from the street. And yeah, I would estimate 10 to 11 feet if you were doing it directly. My architect measured it backing straight out, if you would, and it's 15 feet to the curb cut. So I personally, as a resident here, I have a difficult time. I understand the technical reasons, and I'm not going to argue at all. I just from a practical point of view can't understand why I can't put a carport over my existing car pad. All the neighbors have nice garages, and I think this is just in the style of the carport would be exactly like the house. It's a California ranch style. I have the same posts, the same braces, the same roof. It'll simply look like an extension of the house. And in fact, there is presently an old vinyl fence running along the back side of that, which you can see from the photographs toward the back when you're coming off of 40th Street. And that's kind of what it would look like. In fact, that wall is more imposing than what I'm proposing to put up.
Any questions for the applicant?
If I could just point out one more thing. Right now, we're looking at a series of photos with a car parked on the street, which creates quite an impediment visually, I think. And given all the crepe myrtles that are sitting right out there and that horrendous telephone pole with all the transformers and wires on it, this garage or carport would be practically completely hidden. You'd barely notice the thing. And I'm trying to do this in the most conscientious, efficient, fair-minded way I can think of, the simplest approach I can think of. Right now, I'm looking at the photo with the vinyl wall back there, and it's rather noticeable.
Thank you.
Chair?
Mr. Melnick.
Go ahead.
I have a question of staff. Okay, so I just wanted to make sure that, so these required setbacks are both 25 feet, as it says in the first paragraph, because I see that exception, for accessory buildings, which has, 10 feet, and let's see, and then 1 foot from a side or rear line, but, in the midst of the diagrams and everything, is that the staff's determination that the required setback is 25 feet?
Yes. It's 25 feet from each right-of-way, which for both of these structures would apply.
Okay.
Madam Chair?
Mr.
Is the fence, let's stick with this photo here. Is the fence right behind that sign?
Are you talking about the Arlington Wood sign we're looking at? Oh, we're into a video right now.
So the one on the left there, the wooden fence at the corner of the property. We've talked on other occasions where fences on corner lots have to be a certain distance back from the street right-of-way, or else they have to be no more than 4 feet tall. Right. Did you guys, as part of your analysis, check to see if that fence right there is compliant with that regulation?
I did not look at that fence when...
Okay.
Is it a retaining wall, or Madam Chair, is that a retaining wall or a fence?
There's both.
There's the fence behind
Oh,
it.
behind
The fence.
not the brick.
Not the brick. up-
The wooden
up
fence at the top of the hill.
It's not the stone.
3 feet from the property line?
It appears to be.
Okay. We have another speaker.
Okay.
Jordan Sharp.
All right, Madam Chair, I have a question for this speaker.
Yes, Mr. Owen.
You're also requesting a use permit for a pool house,
Correct.
right? Have you talked to your neighbor at 4001 Richmond Street about the pool house?
No, I have not. But given the topography there, it would, and given that fence you were just talking about, which, by the way, I just want you to know, was put in by the developer of the property behind me called Potomac Crest, five houses that were built on an old farmhouse lot. He put in the fence and the retaining wall and the sidewalk. He went through the whole process with you folks. I just simply gave him permission to do that. But the owner of the property over next to the road, let's say, over by the overpass, and given the tree cover and the fence, I don't think he could possibly see it. But I have not spoken with him, but he's the president of our association and I'm the secretary. So we have a great relationship, as I do with all my other 3 neighbors who I thought would be affected by the project, and whose signatures I have saying they have no objections. So I could I think, I can't guarantee it, but I think I could very easily, and I'd be more than willing to show him the designs, as I did with my other neighbors, see if he has any objections. But I don't think it'll be, barely visible would be my estimate.
Thank you for your response.
Yeah.
Madam Chair.
Mr. Smith?
Mr. Owen, you were asking about the neighbor at 4001? Was that the name? Okay.
Yes.
It's kind of a kitty corner. It's a strange little property, cute house, but odd.
Okay, let's have our other speaker, Jordan. Forgive me, I can't read your last name. But please state it for the record.
Ladies and gentlemen of the board, thank you for hearing me tonight. My name is Jordan Shaheen. I'm here as an agent for Mr. Warden, the owner. And I just wanted to speak on the staff report and the findings that were addressed as far as the motion to deny the use permit as issued. The first point being that there isn't sufficient precedence or other neighboring properties in the area which have this sort of variance is actually something you addressed at the start. It's a bit of a misphrasing on where his property line is versus the street. So it does seem to be closer in written language than it is in reality to posing any obstruction to traffic on the street or to anybody in front of the property. The other point is that, actually, I don't know the date or sort of the history or the look back of the table that was provided in the report. It seems to go back a few thousand cases, so I assume it's a fairly lengthy period of time, but we just don't know exactly how long that goes back. But there is quite a few properties listed on that table on Military Road, which, as you may or may not be aware, is full of other non-conforming setbacks in the right-of-way. I've actually developed a property on Military Road, so I'm familiar with the area. And in the front yards of most of these properties, there are garages, fully enclosed brick garages, no more than 10 feet away from Military Road, which is a much busier, through street with a 30-mile-an-hour speed limit, 2 lanes of divided traffic that are consistently there. So it does possibly leave out that consideration in terms of the date or the timing of these variances being granted, but we just wanted to speak to the fact that there is some precedence in the area for other structures to house cars close to the right-of-way. The second point being, in terms of the line-of-sight issue, obviously we've submitted to you a number of photos and videos that attempt to clarify exactly what you may be hindered in seeing. Because Mr. Warden's property is on the left side of a left turn, it's really not in the line of sight until you're completely through the turn, at which point you're on the other side of 2 divided yellow lines. Now, if the county at some point wanted to widen the road, it's true that the structure would get closer. However, it's being nearly 30 feet wide and serving the traffic that's been there for a number of years without any issue. I'm not sure why the county may do that. There is a suggestion, possibly, as Mr. Risi alluded to, in the DES to put a sidewalk in the area. But as Mr. Warden said, he's open to that. In fact, he lobbied for it at the time when the original sidewalk was put in, but the developer didn't feel that it was worth his cost to add that in because it wasn't serving his Potomac Crest development purpose. So that's my statement for support for Mr. Warden and the use variance. And I hope if you have any questions for me, I can answer them.
Thank you.
Mm-hmm.
Questions for the speaker? Thank you. Ms. Malice?
So to sum up your primary objection, is it that the wall of the carport is what causes the visual block, the line of sight issue?
Yes.
Other questions or comments?
Madam Chair, go ahead.
Sorry. And on the cabana, did staff have an objection to that, or is it strictly on this point?
I think the cabana also, we weren't able to find examples with a similar proximity to a right-of-way, but obviously it doesn't have the visual impact.
Okay, so that's just location, has no traffic impact, okay.
Mr. Owen.
Madam Chair, because of this parcel is somewhat, this neighborhood has, appears to have parcels of non-uniform dimension and of non-uniform topography. And this parcel in particular has some fairly extreme topography. As we can see from the visual materials provided, there's a big hill at the corner. I think that this fence is a much more important visual obstruction than the carport will ever be, and the fence may be illegal for that reason. But I think that with the street dimensions being what they are, with the street location and right-of-way being what they are, for safety purposes, with the hill where it is and the direction of the road where it is, to me, it seems like if you want to make the street safer, the county should build a sidewalk in the right-of-way it already owns. When it does, the carport still won't pose a problem to anyone because there's plenty of room, it appears, to build that sidewalk and still have clearance with the carport. So I as we know from other items we've considered, I'm pretty hawkish when it comes to safety and sight lines and whatever, but I just don't see this carport in this location on this property as presented, causing that particular issue. And likewise with the cabana, I think that the topography of the site and the nature of the property as it relates to its neighbors and the streets around it is such that the cabana seems unlikely to hurt anyone. Although I am troubled by the fact that the only neighbor to me, it seems most likely to be able to see it from some upper story window, hasn't weighed in. That's a real shame, because that would make it more of a slam dunk in my mind. But overall, my inclination is to say yes to this one.
Any other comments? Would you care to make a motion? Mr. Owen?
Sure. Madam Chair, in case V-11323-17-UP1, I move the alternate resolution to approve as advertised.
Second.
With conditions one approved. What?
If I could,
Mr. Melnick?
Okay. So I don't think I'm going to vote for this just because of the staff's analysis. In the first criteria of compatibility development, and they're just not being, because that's really important to me is, the properties around and whether this is compatible. So I think on that basis, my vote would be no. I just wanted to throw that out there.
Thank you. So the alternate resolution to approve as advertised has been moved by Mr. Owen, seconded by Ms. Malice. Is there further discussion?
Madam Chair?
Mr. Owen.
I just want to say that the extra preparation work that both staff and the applicant did in preparation for this hearing, and the extra materials that you provided and the extra outreach to DES were very important to being able to help me navigate this case, and I just want to express my appreciation that people put in that extra work.
Yes, thank you very much.
And Madam Chair?
Mr. Smith.
I found the video to be exceptionally helpful. I was surprised Ms. Malice actually seconded that, because I thought the design of that wall could have been done in such a way to limit its propensity to block, even if it could. But I don't have a problem with the application. I certainly don't have a problem with the pool house.
Okay, good. All those in favor of the motion, say aye.
Aye.
Aye. Opposed?
No.
4-1. Congratulations.
Thank you.
Thank you. Next case, please.
Case number V-11324-17-VA-1 is a variance request by George and Laura Johnson, owners, to permit a maximum building footprint coverage with a front porch of 28.9% instead of 28% as required, regarding a new rear screen porch with decks less than 4 feet above adjacent grade in the R10 zoning district on premise known as 3415 North Vermont Street. Staff recommends that the board adopt the attached resolution denying the variance request. An alternative resolution has been provided should the board decide to grant the variance. Please note there's supplemental material for this case that came in after the application packet was assembled and printed. And if you're going to ask what it is, it's an additional letter of support from one of the neighbors.
Thank you. Questions for staff? Applicant, please. George Johnson, I have a speaker slip for you. It's
Excuse me.
brief. It's 5 minutes, not 20, though.
No problem. Thank you very much for having me.
Sure.
I think the picture is wrong. Not quite there yet. At any rate, I just wanted to say thank you for the time. I am an Arlington resident. I have built a business here, built a family here. I've got a growing family, and I would like to have a screen and porch, even though it only represents a 0.9% increase in the coverage for the variance. To decrease it would be a reduction in the screen and porch area of 25%, which would make it less than suitable for what I'm attempting to do. So my kids have bad allergies to both pollen and to insects, and I would like them to be able to have a suitable place to enjoy some of the outside space for the lot. We bought the lot as it was. It was a built property. And we would like to put this screen and porch on it so that my kids can have a reasonable place to play, hopefully reducing their interaction with the insects in the neighborhood. I would truly appreciate it. I did bring an extra letter, so I've got letters from both adjacent neighbors and from the Civic Association. I was the president of our Civic Association for a couple of years running, and I'm also the committee chair for communications in our neighborhood as well. So I'm in constant contact with the neighbors and the community.
Can we not get to Vermont Street, or do we not have Vermont
It
Street?
appears that we do not have the slides for it anymore. I don't know.
They blended in with the other one.
The video ate them, or
Okay, just, good, okay.
We can go to
Apologies.
Google Maps.
Questions for Mr. Johnson?
Madam Chair?
Ms. Malice?
Are you aware of the criteria for approving variances? I mean, we do many use permits, but what you're requesting here is a variance, which has some significant standards that have to be met in order for them to be approved. Are you familiar with?
I read the packet. I have to admit this is my first time ever trying to receive a variance. I don't do much building or anything else, so except building a family. The house that we bought as is, we bought it. There were very limited houses in the area when we purchased. We knew that we were going to be having more kids, so we bought a house that we thought was going to be the best for us, with the intent always of trying to have a screen and porch. Last child that we did have has got more severe allergies than the rest. We had him while we're in the house, so we would like to overcome that hardship.
I'm just telling you from my standpoint, from a legal standpoint, from what we're required to do, we're required to see if this application meets certain standards for hardship. Like would this smaller porch unreasonably restrict the use of your property? Would it alleviate a hardship due to physical conditions relating to the property? And those are the standards that we use.
Yes.
Have you thought about this application in those terms?
Yes, and so it's a 0.9% increase in the coverage of the lot, but if we reduce the size of the screened-in porch so that we could just build as is without a variance request, that would reduce the size of the screened-in porch by over 25%.
But
that would make it too small for really the kids.
I understand what you're saying, but do you understand the standard that we use for approving variances? You have not described so far a hardship due to the physical condition of the property or economic utilization of the property.
There's no economic utilization. It's just that I'm trying to give my kids something that they can enjoy and not constantly go to the hospital.
Mr. Owen?
When I was looking around, this is a rear addition, and so when we're trying to look at it, it's not like the previous applicant where we can stand at the curb and sort of see the distances in the back of your house, and so it's hard to see. So I went out down Utah Street to try and see through the trees to figure out which house was which. Is yours the house with the trampoline?
It is.
Okay. So I was looking at the right one.
Yeah.
Did you reach out to the neighbors behind you at 3408 Utah Street or 3414 Utah Street?
I had not reached out to them yet. I reached out to both adjacent neighbors and the Civic Association.
Okay. Often, especially when we have a rear-facing addition, the rear neighbors are often, the more affected, and so that's relevant to being able to identify any special issues that we need to pay attention to.
If that would support my case, I'd be more than happy to reach out to both of those neighbors. We've got a great relationship with everybody in the neighborhood. So,
thank you for that response.
Other questions?
Madam Chair.
Mr. Smith.
I guess I would ask the applicant to consider a deferral for a couple of reasons. One is that for the specific reason that Mr. Owen just brought up, but the other is to kind of flesh out the need based on conditions that run with the land or its placement, because your statement of justification is as Ms. Malice pointed out, doesn't go to the kinds of criteria that we can look at. The condition of, your children, their health, and perhaps being adversely affected by the pollen or and the like, don't provide a legal basis for granting any kind of relief. But conditions with the land might, and we don't have, and this is not your property, we don't have the benefit of seeing what it really looks like. I think that kind of puts me in a bad position as a member of the BZA. I don't really have anything to look at to determine whether there is there are hardships.
Madam Chair?
Ms. Malice.
Typically, I think our advice would be to you is to work with staff to try to bring this into compliance. If that could be some redesign of your porch where you would still achieve your goals, but avoid this process entirely because of the justification requirements.
Madam Chair, or to be able to justify it, have an opportunity, work with staff to look at what are the real criteria that you have to meet to get under the bar, because that's just not in the application right now. And I'd not like to just say no as opposed to giving you an opportunity.
Madam Chair.
Mr. Owen.
In my relatively short tenure on the BZA, this is not, I think, even the second, it's at least the third rear porch proposed to be built on a spec property that just about maxed out the coverage. And on 2 previous occasions, the board has voted to deny variances for that. And this seems very similar to me. So I won't oppose a deferral, but I also don't want to raise the applicant's hopes very high on my own behalf, because I find it unlikely that a justification would be shown based on what I already see for a variance. And so I don't want to put you to the work of talking to your neighbors and working with staff and, developing an alternate explanation and waiting months for your project to go through if that's just going to result in a denial anyway. So, but I'm happy to defer if everyone wants to give it a whirl. I just don't see myself eventually voting yes.
Mr. Melnick.
So I have the same thoughts as my colleagues here on the board, especially Mr. Owen. It's rather, the plans do look nice. It looks like a lot of effort's gone into it, but it's rather a non-starter with, the unreasonably restrict and the hardship. As was said, the hardship has to be due to a physical condition relating to the property, not subjectively, what the occupants want to do per se. So I agree. It's, for me, it would definitely be a no now. I don't know what could be come up with, to change that. So anyway, I would vote for a deferral, but I echo Mr. Owen's comments.
So I think we're leaving it to you as to whether you want to, what direction you want to go. If you want to keep this an open matter and work with staff to come up with an alternate design, but I think what we're recommending is that your alternate design find a way to stay within coverage, and then you don't have to come back at all. Then you would be in compliance.
I understand, and I apologize for not fully comprehending the statute as it was written. And I just do have to say that staff has been tremendously helpful. Mr. Rissi has been very, very helpful in the upcoming to this meeting and trying to generate some of the language. I just didn't understand how that language is supposed to be crafted. So,
and it can be confusing just listening because different applications we have different criteria. Yeah. And so if this hadn't been a coverage issue, the standard would be lower, and we could more easily accommodate. But because this is a zoning regulation that is covered only by variances, we have to use a higher standard.
I understand. I suppose I would like to at least try to work with staff, maybe take one more pass at it and try to determine whether we can come forward with a more reasonable argument. And if we can't, then I'll just withdraw before the next meeting,
Okay.
if you don't mind.
Can we have a motion? Yes, Mr. Smith.
I move to defer V-11324-17-UP1, V1, sorry, to the, defer it to the December meeting of the Board of Zoning Appeals.
By Mr. Smith, seconded by Mr. Melnick, to defer this item to the December BZA meeting. All those in favor?
Madam Chair?
Aye. Mr. Owen.
It appears there's support. Usually we defer two meetings, not just the one.
Well, that would have to be February, so that's quite a long.
Okay.
And it wouldn't change the advertisement. It's not going to be, he's not going to come in at 28.6.
Okay. All right, thank you.
That was my view. That's why I didn't go further, because it was the kind of thing that.
Understood.
Thank you. See you in December, perhaps.
Just, Madam Chair, for the record, we should probably, I didn't take my vote yet, so.
Oh, God. Okay.
I vote aye.
Thank you. 5-0. Next case, please.
Case number V-11325-17-UP1 is a use permit request by Eric M. Marion, the owner, to permit a setback of 17.6 feet to the wall, 15.4 feet to the eaves instead of 25 feet to the wall, 21 feet to the eaves, as required from the South Hayes Street right-of-way, and to permit a structure of more than 2.5 stories within 25 feet of a street right-of-way, and to permit a setback of 12.8 feet to the porch, 11.4 feet to the porch eaves instead of 21 feet to the porch, 19.5 feet to the porch eaves as required from the South Hayes Street right-of-way, regarding the renovation of a single-family dwelling including a new 3-story addition and new porch on a corner lot in the R5 zoning district on the premise known as 735 21st Street South. Staff recommends that the board adopt the attached proposed resolution approving the subject use permit with conditions.
Questions for staff? Applicant, please.
Hi, good evening. Eric Marion. I'm happy to answer any questions you may have.
Questions for the applicant?
Do we have a map that shows the neighbor outreach?
We do not have a map for the neighbor outreach, no.
Okay. I didn't see approval from most of the abutting neighbors. So could the applicant describe which neighbors he has written comments from?
Yes, I have written comments from one of my neighbors. The others in adjacent homes are renters. I don't know the owners. I did speak with the renters, and they had no issues with the renovations. The property immediately across the street on South Hayes, I spoke with the owner there last week. He had been out of town, so I talked to him, and he had no issues at all with the changes.
But you didn't get a signature from him or something to indicate that?
I wasn't aware that I could bring additional signatures with me.
Okay.
Other questions for the applicant?
Chair.
Ms. Malice.
So you're doing a rear addition?
Yes.
Have you talked to your neighbor behind you?
That is also a rental. So they just moved in a few months back, and I don't really know the renters that well, and I don't know the owner at all.
So for staff, I guess the owners are notified
Correct.
by mail.
Madam Chair,
Mr. Owen.
I note that staff recommends approval, and most of the board may well agree, but my view is that this addition is it just strikes me as out of scale to the surrounding neighborhood, and with this very anemic feedback from surrounding property owners, I'm just not inclined to support it. So I'm not going to try and persuade the rest of you, but I'm not going to vote in favor of it.
Other comments?
Yeah, that's basically my concern, is that it's a large addition, and we have little feedback from your neighbors. And there's a lot of people that, surround you that are going to be visually impacted by this. And as we often, in deciding cases, look at precedent, and when we start to set a precedent, when there isn't a lot of this going on, and we're very careful about whether or not the larger neighborhood around you is good with this kind of increase. So from my standpoint, I guess I would suggest a deferral until you have a chance to talk to your neighbors. We're okay with you talking to renters. We're fine with that. And staff can also help you get in touch with the owners, because it's public record as to who owns the house, and because it is such a large addition in the back. Obviously, it's going to be very obvious, and in some ways, you may wish that you just get an approval tonight, but you may run into difficulties when you start construction, or even, when you've not legal difficulties, but difficulties with your neighbors when they see what's happening and they feel like they maybe weren't aware of what was happening. So,
and I would say that this, at the moment at least, this is a fairly active civic association, and we know from last month in the backyard gym that they can get very exercised about issues. So I think that it would behoove you to contact the Aurora Civic Association, because quite often, even if we don't have a lot of neighbor input, if we have the Civic Association representatives, that speaks well for a project. So I would suggest that as well.
Madam Chair.
Mr. Smith.
I want to agree with Ms. Malice, and particularly 731. The owner there should know that something this large is going to be built right next to them, is proposed to be built next to them.
Mm-hmm.
I would work hard to make contact with them, so I certainly support a deferral. I think that's the best course of action, because it is large. And it's tall.
Okay. Question is, how much time?
Madam Chair, for my purposes, I think it's neighborhood outreach. So again, I don't think any longer than December is necessary.
Well, if you want to meet with the Civic Association, it's rarely a one-month turnaround.
You're right about that. That does change things. They may cancel a December meeting, kind of a thing, given.
And even to just they only meet once a month, so to get on the agenda and all that stuff. So I would say February would be the right meeting.
how does that fit with your plans?
Probably not.
That's a little bit further out than I was hoping for. And I have, like I said, I've spoken with my neighbors. I don't have their written statements. So that's my fault for not getting their statements.
So we have another application that was on the agenda where there is a rental property, and you saw it before where they came in. They said they changed their plans and they still didn't have agreement with their neighbor, but we did actually get feedback, a letter from the absentee owner who was next door, right? And they wound up making modifications as a result of that outreach. So I do agree with Mr. Smith that the neighbor next to you on your block, as well as the others, frankly. I mean, I don't want to suggest that just one neighbor weighing in is going to be sufficient for our usual expectation, but I do think intense efforts to get actual feedback from the owner that shares your property line is going to be a bare minimum for what I would want to see. And in addition to that, I would want to see some feedback from the Civic Association. And for the rest of the remaining properties, the mailings that the county does, plus your outreach to renters is, par for the course for what we get. But considering the nature of what you're proposing, really reaching over the goal line and getting written feedback from the property owner that shares your property line, I think is really important.
Well, if we suggest December and try to get the ball moving, obviously if you can't do that, we can defer it again to February because there's a known reason. It's not just inattention that we sometimes see from others. So I would rather than, given that we don't have a January meeting and February is, a major delay, perhaps December would just get everything in gear. So you have a vested interest in trying to make that happen.
Yeah, if the stars aligned for some reason, we'd be fine with that. We're just trying to be realistic. But if you can come in December.
I would say I hope that the applicant doesn't come in December and say, well, I just didn't have time to meet with the Civic Association yet. That's the reason to go to February.
That wouldn't fly.
Yeah, to be clear, are you saying that the Civic Association approval is required?
No one's approval is required, but what we want is written feedback from them that resulted from you showing them the plans. And then we can evaluate if they have concerns, then we can evaluate the validity of those concerns, but we want to hear from them so that we can do that evaluation.
And that can even be the Civic Association board. It doesn't have to be a general meeting if it turns out that that isn't often the case where site plans are approved by a general meeting anyway. So if time is an issue and they don't necessarily meet, you may be able to make that happen. I would at least try. Our meeting is fairly late for us in December, so that probably gives you an extra week from what we typically would have between now and then.
And Madam Chair, and the form that you have for neighbor support is perfectly acceptable. Just those, contiguous neighbors, it seems like they should be on here.
Absentee people can be email or whatever, as long as you've reached out and you've made the effort. So I'd suggest trying for December. Can we have a motion to that effect?
I think I didn't. Did I move to defer it to? No, well, I'll move to defer V-11325-17-UP1 to the December meeting of the BZA.
Okay, I'll second it. Moved by Mr. Smith, seconded by Ms. Freshman to defer this item to the December BZA meeting. All those in favor?
Aye.
Opposed? See you next week.
Thank you.
Next month. Next case, please.
Case number V-11326-17-UP1 is a use permit request by Karina Gisela Guerrero Alvarez, the owner, to permit a setback of 0.4 feet to the eave of an accessory building instead of 1 foot to the eave as required from the left side adjacent property line, and to permit a setback of 1.3 feet to the eave of an accessory structure instead of 10 feet from the rear property line as required, and to permit a distance of 2.9 feet to an accessory building instead of 8 feet from the main building as required, regarding the placement of a 48 square foot accessory building on a corner lot in the R6 zoning district, premise known as 410 South Fenwick Street. Staff recommends that the board adopt the attached proposed resolution approving the subject use permit. And please note that there is supplemental material for this case, including a letter of opposition from an adjacent neighbor that came in after the application packet was assembled and printed.
Thank you.
There's additionally a diagram that shows what possible by right location there may be on the lot as well.
So we're talking about legalizing an existing shed.
Correct.
Question?
How did this come to you? How did this application come about?
I believe this started as an enforcement case.
It's not a complaint?
Correct.
Okay. Applicants. Oh, Mr. Melnick.
Yeah, so so I see, that you recommend, the staff is recommending approval, but is there any detail on the fact that, 8 feet is required between the accessory building and the main building, main house, as the 8 versus the 2.9 feet, and, for fire safety, what actually is recommended? Do you know in the industry the minimum, just in case firefighters had to access or get through, or, does the staff any comment on fire safety in reference to what's being requested here?
Staff doesn't have any input on the fire safety now.
Madam Chair,
Mr. Owen.
I'll just observe that I've asked a similar question in the past, and I remain completely at a loss as to what the 8-foot requirement is meant to do. And if one day we learn why we have an 8-foot requirement, what the county board's purpose was in enacting that in the first place, I think that might be helpful on numerous applications.
Thank you. Applicant, please.
Good evening, and thank you for your time. I'm Karina Guerrero, and this is my husband, Roger Goodbow, and I am here to request a use permit for the placement of a very small shed on a corner lot behind my house and out of plain view. That placement would be consistent with the placement of equivalent structures in the surrounding properties of Arlington Heights. I know that staff mentioned the possibility of a very small area where the shed could be placed by right, but in that case, that placement wouldn't conform to where similar structures are placed in the surrounding residences, since the shed would be in plain view in the front of the house. So we would like to keep the shed where it is right now, which is in the back of the house, out of plain view, basically.
Hi, I'm Roger Goodwold, and thank you for your time tonight. I just wanted to make it known that I reached out to DES because I did know that the neighbor complained. Cheryl Parker's who I'm working with, she came out to the house and she confirmed that there's no additional water runoff from the shed or erosion caused by the shed to the adjacent neighbor. Regardless, to appease our neighbor, I told her that we would do something, and we have a plan set, and she's on vacation right now, Cheryl Parker is, but we do have a plan to put a drainage in. I was starting a French drain, but she has steered me in a different route, so I am working with DES, and DES did contact the neighbor that's complaining. I just want to make that known.
Thank you. Questions for the applicants?
So this nifty 5-color drawing that staff prepared, which is quite helpful, shows this yellow area where it would be by right, but there's like a tree there too, isn't there?
The tree on the left, a large oak tree.
Yeah. So that would be a sort of a silly place to put it. But the question is, in my mind, you do have a very large paved patio now behind your house. And it strikes me that there might be other places on that patio less visible to your neighbor where it still might be hidden by the fence. And have you considered other locations on the patio area? And you still need a use permit from us to get it closer than 8 feet to the house. But have you considered other locations that are farther from your neighbor?
We did at one point, but if we move it to this picture here, every neighbor will see it, not only the two that are adjacent to us.
Mm-hmm.
But on this side, everyone driving down the street will see it.
Every person who walks by,
Then
and
it would be in
so
plain
many
view.
people walk by with their dogs and everything, it will be way more
It
visible.
would affect 1, 2, 3, 4, 5, 6, like 7 houses instead of 2.
And if you walk around the neighborhood, you don't see the sheds in that location in the rest of the houses.
And that's our common area of where we eat.
Have you considered a shed or box that is shorter?
This shed is only like 7 feet, 4 inches.
Right, but because the fence is so tall and opaque, right, if you had a little bit shorter structure, then it wouldn't be visible at all. And I'm just wondering if that's an option that you've considered.
But if you look at the pictures, you can barely see the top from outside. I don't know if...
We didn't consider it. I mean, we purchased that shed. Didn't think there was going to be an issue. So at the time of purchase, it was very small. dwarfed by everyone else's sheds in Arlington Heights. So we didn't think it was going to be an issue.
Yeah, I did notice in the neighborhood that what you're saying, which is that there's lots of other sheds that are bigger than yours. That's for sure.
Way bigger.
Thank you.
Madam Chair?
Ms. Malice.
Just to follow up on the shed location, would you say that placing it elsewhere on the patio would make it more visible to others?
Correct.
But that's for others to worry about. For you, from your standpoint, would it work?
No, it would not, because that's our common area. This is a dead space that we have in the corner. There's nothing over there. The other area is our patio area where we sit, we eat, and there are couches.
And our kids play there
Yeah, so
too.
But it's a small shed, right?
Yeah.
So it wouldn't take up that much room on the, I'm just trying to figure out if there's any alternatives here.
Yeah, the size definitely would be the same. It would be the same shed that we would place
And-
anywhere else.
And the shed, and the fence on that side is substantially lower as well. This is a 6 foot, or it's a 7 foot on this side. You'll really see it on the other side. And it'll look out of place, in my opinion. It won't be aesthetic.
Yeah, it won't be, yeah, the fence is not as high as in that picture on the other side.
No doubt.
So it will be more visible, way more
From your
visible.
standpoint, it's this location or nothing?
Well, that depends, I guess. I mean, this is where we'd like it. This is where we think that it looks best at our house, and we wouldn't want it to be in our common area and have to walk around it or.
And it looks aesthetically well there. It will look kind of misplaced in that common area to have a shed. So it makes the house look better.
Okay.
Okay, thank you.
Thank you.
I have two speakers. Carol Lieber.
Thank you for the opportunity to address the board. I object to the requested current location of the shed, and I also believe the analysis is flawed. In the analysis provided by the staff, point 1 stipulates the overall footprint in size is compatible with actually much smaller than numerous other accessory buildings in the surrounding area. In support of this, a chart's been included to compare similar properties. However, the report actually shows that 9 of those 10 structures are garages, not sheds. All the garages, with the exception of the garage at 301 South Fenwick Street, were built prior to 2005 and thus were grandfathered in the current code. The current garage at 301 South Fenwick Street does not meet the setbacks. There's also a small shed there. The county has approved 2 building permits in recent years. It's not clear why at that time they didn't address the setback for the shed. Excuse me. The chart also indicates 2 properties that are closer than 8 feet from the wall of any main building, the small shed that I just mentioned, and also the garage at 3105 South 6th Street, which predates the 2005 requirements, and which further is an interior lot, not a corner lot, as mentioned on the page. The county's provided no examples of any accessory structure that's less than 8 feet from the home, in addition to being less than 1 foot from the side. This shed totally blocks my view. It serves as a de facto 9.5-inch fence. You can see in the picture, the neighbor stipulated that's a 7-foot fence. The view from my side of the house, from my lot, is the house and the shed. I have no sunlight. I have water pooling caused by the erosion from the shed, which I have been asking the neighbors to deal with for 6 months. The impact of an additional shed in that property is compounding the situation. I'm concerned for what's going to happen in the winter. I have water pooling there now. Is that going to be ice? Am I going to have ice on my driveway? So thank you for your time. I don't want to go over your time, but I appreciate your attention to this.
Thank you. Thank you.
Madam Chair, I have one question.
Speaker, yes, question?
The applicant indicated that you may have been contacted by DES. Is that true?
By DES. DES contacted me on November 7th to tell me that my next-door neighbor had contacted them to meet with them about the erosion. They have been trying to meet with him since June.
Thanks.
Thank you.
Thank you. John Mashaw?
Good evening. I'm a neighbor and a property owner to the immediate south of this house. I've been there since 1994, and I'm simply here to speak in favor of granting the zoning variance as presented here. Again, I've been there for a long time. The siting of the house on this lot has caused very awkward possibilities for property use, and I find that actually, if one of the possibilities that I think they tried was putting the shed on the far side of the house, which you would see, which is not a big deal. It's on my side. I'd be looking at the house. You don't see but a little bit of the top, although they did need to reduce, he didn't mention this, but they had to lower the fence a little bit to comply with code after the whole thing was put in, and they did that with no argument, just this is what we need to do. But finding it there, the only thing you can see is that there's a lot of trees right there, which for the 20-some-odd years I've lived there haven't been trimmed very much anyway, so you can't really see it. At least you couldn't for 2 decades. So I simply speak in favor of the variance. So thank you very much.
Thank you. Any other questions for the speakers or the applicants?
No questions, Madam Chair, but it's, Ms. Lieber raises a number of issues that haven't actually had time to read the entire letter in terms of what the concerns are, but one is I guess the visibility of the shed, the other is a water runoff issue, and there may be others that I haven't gotten to. May I ask Ms. Lieber to just summarize any other issues besides those two, if you wouldn't mind? Besides the placement, visibility from your and the water, are those the 2 issues that you're working out?
Those are my main concerns. For the record, when Roger came over and asked me on September, I believe, 5th, to sign the petition, he told me that he had actually wanted the shed on the other side of the house where it was placed before, but the county told him that it was in violation. He asked me to sign the petition. I told him I had my major concern was about the erosion, which he knows. We've had some discussions about that, and he's assured me over the past few months that they were going to build a drainage system. But I don't know why now I'm hearing that the prior location is not acceptable, because that's in fact where the shed was when the county came in and said the shed's in violation. That's per the conversation that Mr. Goodball shared with me. So my main objection, the erosion has been ongoing. It's been unabated. It's gotten worse. I've had to spend a lot of money to try to remedy it. I've tried to do some mitigating factors. I've purchased mulch. I was told I should put up some bricks and cover it with mulch. The neighbors objected to the fact they had mulch on their property. I've had advisors from Fairfax County come in. I've paid for landscape architects from Meadowfields to come in and advise me on it. I've had contractors come to my house to look at my concrete patio and my asphalt driveway, who expressed concerns about the erosion on my property caused by the runoff by my neighbors. So my concern is having the shed at that property, even though it's a lightweight vinyl shed, which has been moved 3 times since it's been erected, it does have the effect, when it's full, of continuing that erosion on my property, and I'm very concerned about that. I have mushrooms growing on my property that I never had growing before. I've tried everything that I can to try to mitigate it.
So 2 issues. One is just visibility, and the other is the erosion.
The visibility, the erosion, and the icing. I'm very concerned about what's going to happen when my whole driveway is blocked. This addition, what you're looking at in this picture here, is an addition to the house that was built within the last 2 years. Prior to that, there was a carport there. You have information in the packet about the carport. There was a 3.5-4-foot fence at that location. So with the addition of the of the second bedroom. I already had problems last winter with ice melting on the driveway, but at least I had some sun coming in that little sliver where the shed is now placed. And so I'm concerned that I'm going to have continued icing. And I've had a number of surgeries in the last few years. I've been on crutches. I was on crutches for 18 months with 2 torn meniscus. I'm just coming off having rotator cuff surgery. So as you can imagine, especially as a senior citizen, I don't like to say it, but I'm a senior citizen, I'm concerned about slipping on ice and falling. So that's another one of my concerns with the placement.
I understand you to say that the water erosion issue is from the addition that was built?
No, the shed, the patio. What's not shown in the paperwork, it's not on the plat, but in, I believe, May, the neighbors built a concrete patio. It's not reflected on the patio, nor is this vinyl fence. And they put a drain underneath the patio, and they elevated the land. There's a picture in what I submitted to you. They elevated the land at that point and put a drain. They elevated the fence so that the drain actually dumps directly onto my property.
But the shed.
The shed is an impervious object on top of an impervious substance. So it's a concrete.
More or less pervious. I mean, it's no more pervious than just concrete. I mean, it's the concrete pad that's causing the water problem.
But the fact that the shed is blocking the sunlight from coming and melting the ice creates a problem that I otherwise wouldn't have if the shed was there. And I want to say for the record, I have no objection to my neighbors putting the shed on the opposite side where it was located before the county told them that it was in violation.
Okay, thank you.
Mr. Melnick.
I'm wondering, this is, your classic case of, a neighbor having an objection, based on what appear to me to be logical type things. They make sense, and I know that there could be probably, although I see the drawing, with the setback lines, whether the applicant would want to defer, just to further consult to try to see if some kind of resolution can be reached with the neighbor, even if some exception is needed in the future, but just to try to mitigate some of these things about the water and the fungus and no sunlight. Is that feasible, a deferral for more conversation?
We already are working with DES to deal with the water issue. So we already have the plan in place to deal with the water, so that's a moot point, isn't it?
So is Ms. Lieber aware of your plans?
Yes, and they contacted her and spoke with her, and she admitted that. And also, just for the record,
Can you describe what your plans are?
First I was going to do a French drain, and that's why there's a drop-off. I started digging. But she has advised me to buy an elbow extender and then the tube to go around the property line and back out to the front of my yard.
DES?
DES, yes, Cheryl Parker. And going out to the middle of my yard so that it disperses, evenly in my yard. And also, for the record, when we did have all the snow last year, I'm the one who shoveled her driveway, her front sidewalk, her stairs, and her porch.
One time when I was out of town, I appreciated that.
Yeah, so if there's any issues with ice, she can call me. The driveway is not adjacent to the shed. The walking into her porch is not adjacent to the shed, and I'm more than willing to help her. I got her ice when she had surgery. I help her with her lawnmower. So I'm kind of at a loss.
Presents and pizza when your baby was born.
Well,
Okay.
I mean,
No, ma'am.
but
Thank you.
Just for the record, I wanted to make that statement. If there's ever an issue with her.
This isn't a contest. This isn't
exactly.
a reality
Well, what I'm saying
show.
is if there's issues with ice.
Tell me when do you plan to?
We have she said 2 weeks. She'll be back. Cheryl is on vacation. I have to get the grade right. I have a level, so I'm now determining the grade so that it runs out properly, and then she's going to come back and inspect it in 2 weeks.
Okay, so
That was from last Monday because she went on vacation for Thanksgiving.
when do you think the water issue would be corrected?
2 weeks from now. It should be. I mean, as long as she signs off on it, everything works fine. 2 weeks.
Okay.
But the water issue has nothing to do with
The shed itself,
which
so-
is what we're talking about tonight.
Madam Chair,
Mr. Owen.
I don't have any questions for the applicant, but I have some other comments. So if others have questions for the applicant, I can hold off.
Are there other questions for the applicants? Mr. Owen.
So part of the challenge here is that what I'm seeing is that the construction of the patio and the fence, which ultimately are by right, have sort of worn down the, I want to speak generally. I don't know what's exactly happened in this particular case. I don't know you. I actually have met your neighbor, but I don't know your other neighbors, and I don't live in the neighborhood. But what we sometimes find is that people, the way staff analyzes these things is they say, well, here's what you can do by right, and then here's what you can do with the permission of the BZA. And then from their perspective, the scope of what they're looking at is just in this tiny little universe of what does the BZA have to do. Meanwhile, your neighbors are not looking at that. The neighbors are looking at the big picture, right? And so what I see here is that the fence and the patio have been big and new, even though they're by right. And so your neighbors take some time to get acclimated to what that impact is on them. And then they're kind of worn down by all of that. And so when you come for this tiny little bit of extra, that has to go through the BZA, then people are like, enough, that's the last thing. It also can happen when there's lengthy construction, So the neighbors were actually signing off and saying, yeah, build an addition to your house, but then construction goes on 2.5 years. And they say, well, I just want to change the eave another 6 inches. And they're like, no, I'm not signing anything more, enough. So I feel like maybe that's kind of the dynamic that may be in play here. So it can be a little bit at odds because staff is saying, well, let's just look at what the shed is doing, but the neighbors are looking at this bigger picture. So I'm sympathetic to the notion of, can we see, in a month, how the drain worked out, and if that's really the big problem that's creating the emotional tension here, does that create the leeway to restore neighbor harmony and get some kind of agreement? So that's sort of what I'm wondering about the situation. So that's not a question for the applicants, but that's just sort of my approach.
Madam Chair.
Mr. Smith.
That was very well put, Mr. Owen. It's not, I agree, it's really, I don't have a problem with the shed. I'd give time so that you all can try to talk through and maybe see if the work that you're doing to mitigate runoff is helpful, but I don't see it in relationship to the shed having anything to do with it, really. I really don't see much obstruction of light. The sun moves. The amount of light that that peak will obstruct for the short period of time that it does won't have the melting effect that I think you'd hope that it would have, but I'd be prepared to approve. I don't have a problem with giving you all more time, but it's so that's kind of my position, Madam Chair.
Any other comments? Okay. Anybody want to make a motion?
Madam Chair, I move that the Board of Zoning Appeals in the matter, in the matter V-11326-17-1 defer this item to the December hearing.
Second.
Moved by Ms. Malice, seconded by Mr. Owen for deferral to December for the reasons spoken. All those in favor? Aye. Thank you. Next case, please.
Case number V-11327-17-UP1 is a use permit request by 30 3845 Military Road, LLC, the owner, to permit a left side setback of 5 feet to the wall with 5 feet to the eave instead of 10 feet to the wall, 6 feet to the eave as required, and to permit an aggregate side yard of 13 feet instead of 24 feet as required regarding the new construction of a single-family dwelling in the R10 zoning district on the premise known as 3845 Military Road. Staff recommends that the board defer the use permit to the December 2017 Board of Zoning Appeals hearing.
Questions for staff?
Madam Chair, is
Mr.
this
Owen.
item out of order? Is this,
No, not according to the agenda.
did we do 410 South Fenwick Street?
That's what we just did.
Yeah.
That was the shed.
Oh, I'm sorry. All right, my apologies. Sorry.
Staff has recommended deferral.
Madam Chair,
Mr. Owen.
I move that in case V-11327-17-UP1 that the BZA defer the item to the December 2017 BZA appeals hearing, BZA hearing.
Sandeep.
Sir, are you the applicant?
Yes.
Do you have anything you want to say before we?
Sure, I appreciate the opportunity.
You requested the deferral, I did.
Yes, I did.
Yes.
I started the process in September and, also circulated the copies of the material to the neighbors, the most immediate neighbors surrounding the house. And I was able to meet with some of them in September, but some other people who were not available, they got back to me in November. So early November, we had a meeting, and they provided me some feedback regarding the visual appearance of the house, and they had some more things to share about the history of the property. What I'm looking at here is that this is a lot which has been laid narrow or rendered narrow because part of it was acquired by the Commonwealth of Virginia for highway purpose. So out of that hardship, what has been left is that if I develop the lot for a home like this, it would be a very narrow 20-foot wide and a long 80-foot long home, which would not be compatible or nice in the neighborhood. So I reworked the proposal to widen the home to approximately 30 feet wide within what is possible working with the staff. And that's what I wanted to communicate over to the community. It so happened that the design that we worked on had a smaller front yard and a larger backyard out of a certain choice. And the neighbors said that what would be more compatible would be to have a bigger front yard and a narrower rear yard. That would be something that I communicated that I'm willing to consider. It would require some time and cost on my part to rework the design. And also, because the driveway would become larger and the house is already smaller, it would potentially require me to request some variance for dealing with that hardship. So at this point of time, I'm also exploring other ideas to make that corner a little bit more beautiful so that the neighborhood and the civic community can support it by trying to explore if the Commonwealth of Virginia or VDOT would permit us to mow the corner of that property, which is belonging to them, at our own cost, and that would improve the visual appeal and the scale and scope of how the property looks there. So I've sought a couple of weeks to work on this issue, and hopefully I can come back to you in December. It's extremely expensive, so I'm trying to work as rapidly as I can, and I'm welcome any questions that you have, and also, if you have any suggestions, I'm here to take them.
Thank you.
Madam Chair, did I understand you to say that by setting the house back further, you'll need a longer driveway?
That's correct.
That might cause you coverage issues.
That's correct.
That it may then require a variance.
Right. Correct. We're aware. We're working closely.
In December is enough time to do that?
By the community concern of the front yard setback.
But they might meet the criteria, right? because they have an unusually shaped and sized lot.
Agreed.
Okay, so I believe that Mr. Owen actually made a motion.
Yeah, I
which-
did. I'm so sorry.
It's no worries.
I do
It's no
actually,
worries.
as long as everyone's here, I do have a question. On the financial disclosure, I was a little bit, the handwriting was difficult for me to read on the financial disclosure. So who owns the property?
I do. It is in a LLC. But I'm the single member of that LLC.
You're the sole owner of the LLC. All right. Just, I would take, since you're getting more time, just work with staff to review the financial disclosure and make sure that's completely clear on the financial disclosure. Thank you. All right, Madam Chair, if you're so inclined, I'll make my motion.
Seems that I'm only in need of a second.
All right.
Second.
All right.
Okay. Mr. Owen has moved and Mr. Smith has seconded to defer at the request of the applicant to December, BZA. All those in favor? Aye. Thank you. See you in December. Next case, last case.
Case number V-11328-17-UP1 is a use permit by Julie Wilkins, the owner, to permit a front setback of 9.9 feet to the eaves instead of 21 feet as required from the North Dinwiddie Street right-of-way, regarding the eaves of a second-story addition being built over existing walls in the R6 zoning district on the premise known as 2318 North Dinwiddie Street. Staff recommends that the board adopt the attached proposed resolution approving the subject use permit with conditions.
Questions for staff? Applicant, Julie Wilkins.
Good evening, Julie Wilkins. Any questions? Happy to answer any questions. Okay.
Mr. Smith.
Why aren't you building a McMansion?
Because the yard's so big. It actually looks pretty big there.
Yeah, it does.
It's just the wide-angle lens. The lens.
Yeah.
It's a small structure.
It's nice. Okay, any other comments or questions for the applicant? We have a speaker. Dave.
I'm just representing the builder, and we're doing this to put the eaves back, actually smaller than what they were to begin with.
They were 18, and
They were 18, now they're going to be 12.
Just straight
Above
up.
the existing wall.
Okay.
And to match the aesthetics of the neighborhood, right?
Okay.
Which is this.
Questions for either of the speakers? Thank you.
Madam Chair?
Mr. Smith.
This is the kind of building I love to see. That it's like 100-year-old design that someone's putting in today. It's not a McMansion. It really does have character. And therefore, I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in V-11328-17-UP1 subject to the conditions.
Second.
Moved by Mr. Smith, seconded by Ms. Malice for approval. All those in favor?
Aye.
Thank you. Thank you. That concludes the agenda. We have minutes.
That's nice. And I'm not mad at the other.
How would you like to handle this?
Madam Chair, if I may, in your supplemental package, you'll find revisions to the September 20th minutes, October 16th, and October 18th minutes based on some edits that Mr. Owen shared with me this morning. The August minutes are unchanged.
Okay, let's go. I have motion to, okay, Mr. Owen.
I move that the BZA approve the August, September, October 16th, and October 18th minutes as amended.
Run those dates by again. The August.
August. August 9th. August 9th, September 20th, October 16th, and October 18th. August 9th as proposed, and the September 20th, October 6th, October 16th, and October 18th as amended.
As amended, okay.
So I want to second that, and I want to thank Mr. Owen for his
Diligence.
Yeah, his diligence.
Okay, so it's been moved and seconded to approve four copies of the minutes, various minutes, and we're now current. Is that correct?
Yes.
Excellent. Thank you for everyone's hard work. All those in favor?
Aye.
Aye. Miss Mouse.
Bring up something. Today, Mr. Lawson gave us some news about additional laws that apply to us. I hate to get the news that way. Is there a way that we can be brought up to date on what case laws are affecting how we're supposed to be reviewing applications?
I'm not even aware of what Mr. Lawson gave you today, so I can't even.
Don't either.
Madam Chair, let me co-sign what Ms. Malice said, and I guess I'd ask the zoning administrator to develop a better relationship with the county attorney's office, because this is a really germane case for BZAs. And there was another case, I think it's Franklin, that came down from the Supreme Court a couple of months ago. Really important case for BZAs. I just happen to, on occasion, Google and look at the Supreme Court stuff that comes down, and but I think they should be letting you know when stuff happens like this. And that other Franklin case, I don't
Yeah,
remember.
there was a case, I don't know which of either of these or it's yet another, but but I did see a case about the impact, the legal impact of a,
By staff.
yeah,
Yeah.
which is something
That's
that's
the
come
one.
up for us, yeah.
Yeah, that was a real.
So, yeah, I have to admit that I, since I'm still associate member of the Virginia Bar, I sneak onto the Virginia Bar's search engine and type in zoning every couple of months. And but I agree that it would be super if somebody could let us know when there's a major case coming down.
I mean, especially those of us that aren't lawyers, you know, like what changed that we're supposed to.
Yep.
Because even if we read that, we might, you know, we need something to.
Yeah, we need interpretation. And if it affects even what we have to announce at the beginning of the meeting.
And I feel the same way about any BZA case that occurs in Arlington. Yeah. You know, the Arlington Circuit Court is our boss, and so we should know what they're doing that affects, you know, land use. I mean, not even.
5-0 on that case, by the way. We all got overturned. I wasn't.
Okay.
Really different.
Okay.
That's a good. I looked at. I guess we got a copy. Ms. Vaughn, thank you. She sent me a copy of that because I asked for that.
Yeah.
That was helpful. That was instructive. I think we should.
The Virginia Square BZA, Virginia Square CVS case, yeah, the Highlander.
Huh? No, I didn't quote it, but I asked what was, because, you know, what were the, you know, what was the outcome, what was the ruling? But yeah, we should, that was, I think they should kind of package that for you or for, for you and then.
It applies to you. You're supposed to be interpreting the same law that we're supposed to be interpreting.
I actually called the county attorney's office to get a copy of the briefs in that case, and they gave it to me, but they treated it as a FOIA request.
Yeah. Did they charge you? How much?
No, they didn't charge me.
They didn't charge you? They didn't charge us.
Yep. So if this is something that we should not direct to you, but we should direct to somebody else, I'm sure we would be happy to do that. So I don't want you to feel like, I wouldn't want you to feel, I don't want to speak for my.
I was grateful.
But I don't, if you're not the right person to talk to about this, let us know who we should be talking to, and maybe we can do that.
Just the advice that I've been given for appeals, so for cases for which applicants appeal the decision of the BZA, what I've been told is basically I shouldn't be talking about it with anyone while that's active. And so if there are questions about an appeal at the circuit court, they should all be directed to the county attorney's office, just as a matter of course. For the other matter, we can certainly inquire.
So maybe I think the question that's coming up in my mind is, should there be some kind of ground rules for a direct line of communication between the BZA and the county attorney's office for certain kinds of matters, for informing us about the law and changes in the law or major cases, as well as informing us about BZA, literal BZA cases. It used to be, until just a few years ago, that BZAs were parties to those cases. And so we would get legal notice, and we would be served, So to go from being served parties to total ignorance is a big switcheroo.
So the chair gets served
I get
for
served,
appeals.
But maybe
You're no longer party, so that did change.
I was going to say that had happened to me, but it was years ago when I
Right.
chaired.
Right. So, yep. So I echo that. I have another matter, whenever we're finished talking about this one.
Go ahead.
But if you feel like we should talk to the county attorney instead of you, let us know if that's your view. The other matter is that we had a case 6 months ago where there was some confusion about whether or not they should have been applying for a variance and a use permit, or whether their variance was already still in force from the last go-around. Do you remember that? And so on the fly, mid-meeting, we all came to the conclusion that they didn't need to do the variance, so it was withdrawn as unnecessary. But it turns out that might have been all wrong. And so I wanted to get an update on that parcel if we have one.
So I checked Permits Plus before coming down. The building permit has been approved. Its review has been approved by zoning and approved by ISD. It has not been issued. There's a note basically saying, and this was, the last approval occurred on Monday. The deadline is the 17th. The note basically says that they have to slip sheet. There's one sheet, I think, that needs to be updated. It doesn't require another review. It's a simple matter of an applicant making a copy at Kinko's, bringing it in, and inserting it into the set of drawings that we have here. But again, so that's certainly feasible for them to do by the deadline. I have no idea if they're going to be able to get it done by then. So it's almost issued, but not as of today, not yet.
The use permit that we did approve may vest before the 17th if this building permit goes through, and then they'll be secure with a valid use permit. And then the question is, what's their status as to the variance?
Right.
And so if the building permit doesn't go through, they have to reapply for the use permit. And so if they have to reapply for the use permit, we could just inform them that we screwed up and the variance needs to come back to us in the same cycle. But if they vest in their use permit, they're in their minds, they don't have anything more to do. But we know that something needs to be cleaned up on the variance. And so my intention is, if they vest in the use permit at the December meeting, I would move to reconsider our motion to accept the withdrawal of their variance and just put it back on our docket. That would be my motion.
Does that have to be advertised?
I bet it does. So then the action on the variance wouldn't occur until the subsequent meeting. So that's the situation we're in.
Just make that motion now.
Do you want to advertise it now?
Well, we would have time.
You can't.
Would that be prophylactic to make it now?
How can we make a motion on something that's not advertised?
To reconsider it in December.
The motion would be to advertise it for a meeting, for reconsideration at a particular meeting.
Do you need a motion to have it advertised?
They haven't applied for anything? So.
Oh, I don't think you do need a motion. That's right.
So like sua sponte.
The staff could just advertise something on its own and make a recommendation to us that we move to reconsider. I like that option.
Okay.
So we'll see what happens in the next 2 days.
So
See what happens in the next 2 days.
Application requirement.
There's, right, their application was already in. It's just to reconsider the thing we did, whatever it was in May, or thereabouts. And so the item that staff would put on our agenda and advertise is a possible motion to reconsider that variance, and then put it on our agenda, advertise it, send it to the neighbors, and then at the December meeting, we could decide whether or not we want to reconsider that motion, and then we could act on it that very same meeting.
The administrator is asking the BZA to reconsider.
And approve.
And approve, yeah. If that's their recommendation at that point.
Right.
But to reconsider, yeah, okay.
And the 17th, you'll know, and that's within the advertising deadline.
Correct.
And you, right, okay, great. You okay with that? You guys okay with that?
Sounds like a ZA power. Yeah, I don't have a problem with that. I'm glad you said do it now.
Yeah, other than,
It'd be February.
right. And then
Okay.
they have a permit that they can't.
Any other housekeeping issues? How about moving to adjourn?
I'll move so.
Second.
Move to adjourn. All those in favor?
Aye.
Bye.
Good job.